Well, it's just gone 27 to 7 on this Thursday, and it's time for the concluding law panel this week. So far, we've heard the thoughts of the Competition Commissioner, Teminkosi Bonakele, on how the criminalization of cartels will be handled, and I was certainly left scratching my head as to how, in practice, the process is going to work, considering there's no MOU with the NPA yet, and all sorts of questions still hanging around that one. On Tuesday night, we heard quite convincing arguments, I thought, from Bernard Swanepoel against the current revised draft mining charter, as well as opinion on the fact that the minister appears to have been poorly advised, as the charter might not trump the MPRDA. In fact, it won't trump the MPRDA, and therefore, once the once empowered, always empowered court case ruling is ruled upon, or court case is ruled upon, that will actually hold sway. So very interesting thoughts, those. Last night we discussed the future of trade unions, as we see certainly the role and function of trade unions in South Africa coming under quite immense pressure, tectonic shifts, as we see NUMSA breaking away from COSATU. We had that May Day rally and the announcement of a new federation in formation. So we really questioned the role of trade unions. And we also had Statistician General Pali Lehlokla talk to us about what he's seeing in terms of unionization rates. They've sort of flatlined a little bit, come down by about 3% or so over the last decade. But he really left us with quite eloquent comments about the state of our education system, and really being the fact that we've shown alarming signs of regression. And ultimately, this must trump all if we're to hope for a prosperous future for the youth of the country. We've been putting the big legal issues front and centre on the panels this week on 102.7 FM. As the internet chips away the barriers of entry, we certainly see all sorts of questions being asked around how creators, how the inventors, how the content producers can monetize what they share and what they distribute online. And it raises questions about how to apply traditional copyright laws to intellectual property on the web. And we've had some interesting recent cases involving MoneyWeb and NASPA subsidiary Fin24 that certainly clarify some IP issues, while we've also had some disturbing proposed regulation. Government's highly criticized National Cyber Crimes and Cyber Security Bill, and that's shortly going to be taken through the parliamentary processes ahead of implementation, according to the State Security Minister. We've also got the Film and Publications Board draft internet censorship regulations, as they've become known. So no easy matter wading through all of the issues in the IP space, and I hope the panel tonight can shed some light on these challenges and how IP law is responding. I'm sure they will be able to. It's a great pleasure to welcome to my immediate right, Hugh Melamdowitz, partner at Spur & Fisher. Hugh, thanks for coming on down.
Thanks, Michael. Thanks for having us.
And right next to you is Vicky Stillwell, trademark attorney and consultant at Quiche IP. Vicky, welcome.
Thanks, Michael. Thanks for having us.
And on the line, we've got Janine Hollison, director at Worksman's Attorneys. Janine, thanks for joining us.
Thanks, Michael.
Hugh, I think I'd like you to kick us off here and perhaps just set the scene, because ultimately intellectual property rights are there to protect the creators, the original producers of content. How is this enshrined in our South African law? In the EU, for example, it's a fundamental human right.
Well, it's part of our constitution. Our constitution recognizes the right to property, and that one cannot have property alienated. So it does form part of our inalienable rights. However, again, as with everything, it has to be weighed up with the reasonableness of the rights, and in certain circumstances, that right can be limited again by way of legislation. And I think that was highlighted in the that Media 24 MoneyWeb case.
Yeah, a very interesting case indeed. And, just to bring it down to sort of layman's speak, I mean, intellectual property, when you misappropriate it, it's theft at the end of the day if you take an original piece of work and pass it off as your own.
Absolutely. There's been a recent judgment which has said exactly that if you steal someone else's idea, basically what you're doing is it's theft, bottom line. And that's what we're trying to protect.
Vicky, talk to me about how law and policy respond to this increasingly seamless flow of content, especially in the realm of the internet. How has the law evolved and responded up to this day?
Well, it's quite interesting, Michael, in that our Copyright Act is fairly old in the scheme of things, but the principles are still being applied and can be applied even in the context of digital media and the internet. I think the principles haven't changed, just like when in the days of print media, one couldn't take or copy a story in its entirety and reproduce it. The principle remains the same.
Janine, talk to me about what happens to a photographer, because you've actually done some pro bono work helping a photojournalist recently in that exact space where she discovered her photo, a picture of an aloe, which is a quite stunning picture, very artistically done. She discovered that the aloe had been reproduced and placed on a pillow for commercial gain. How did that come about, and what were the key issues at play here?
What is very difficult for photographers and also with Google Images is that it's so easy to cut and paste, and that's what the photographers have the challenges. What had happened in that case is that Laura Cook had contacted me about the use of her image, and apparently 6 kilometers of this fabric had contained her aloe image. And as you know, legal costs do escalate, so then I did agree to do it for her on a pro bono basis, particularly due to the fact that the attorney that was acting for the designer really did shrug me off and said to me the defense was really that I found it on Google Images, which means it's free. So I think that's really something, a concept that has to be taken out of the public space and think that it's out there on the internet, that it's free. Everything, I think that people out there, consumers, should go from the premise that if it's on the internet and an image is out there, that someone created that image and that there will possibly be copyright ownership and that there could be restrictions or most likely be restrictions on the use thereof.
So bottom line is, if you go and search Google Images, those images are not just a stock photo database for your personal consumption. They're not free, and one has to be quite careful. The problem, though, Hugh, is that the enforcement of this kind of IP is very difficult sometimes. I mean, depending on how you're using it. If you're a small flea market stall and you're taking an image and putting it maybe on a few mugs that hopefully someone might not see, and you're taking it from a foreign country, then you think, oh, well, I can get away with this.
Absolutely. I think for me the big difficulty with copyright litigation, in fact any intellectual property litigation, is the return on the litigation. Generally speaking, the amount that you're going to recover is minimal. You're doing it because you're trying to prevent or to look after your work and to ensure that your work is not copied in the future. What you're entitled to is damages, which is very difficult to prove. And the alternative that our Act provides was a reasonable royalty. And once you do the maths with a reasonable royalty, there's really no money in it. 10% of the retail selling price is really very small, which is pretty much what one would be entitled to. So what one is looking for an interdict, and it's going to be interesting to see whether or not in the Media 24 matter they take the recovery of damages or the reasonable royalty any further, because they got an order that they're entitled to recover the damages. But as I say, it's really not economically viable. It's really the principle of getting the interdict that one's looking for. And the cost of litigation is high. So whether or not it's economically viable needs to be weighed up by the client, by the person whose work has been infringed.
Very important points, those. And Vicky, let's go to that Media 24 case before we get ahead of ourselves here, because despite the fact that, as you said, our Copyright Act was promulgated about 4 decades ago, it's an old piece of legislation, there aren't many instances in which the courts have been called upon to interpret the provisions of the Act. So this was quite eagerly anticipated. Take me through the background of the whole MoneyWeb Media 24 fracas.
Well, just to summarize, the facts are briefly that MoneyWeb sought a declaration that the publication of 7 articles by Media 24 under its Fin 24 banner was unlawful, in that the publications of those articles constituted infringement of its copyright. at the end of the day, to cut a long story short, the judge only found that there was infringement of one article, so and made quite an adverse costs order against MoneyWeb.
And as I note in Rob Rose's editorial in the FBM today, Fin24 paraded this as a victory because only one was found to have been stolen, but you steal one item or 7 items, theft is theft. So I don't want to get into a mudslinging battle. What were some of the key findings from the court ruling from a legal perspective that shed some new light on what media can do here? Because we live in an age that is highly digital, and it seems to me that we've now created a precedent where the first journalist to a breaking news story has all rights, and then everyone can disseminate from there. But if the first journalist gets things wrong, and I was mentioning to you offline the Judge Hilary Squires case, where it was widely reported that there was this generally corrupt relationship between Sheikh and the president. And then Squires came out quite some time later and said, well, no, I've been misquoted. Go and reread the judgment, which everyone did. And much to everyone's horror, he didn't actually say that in that many words. So we need to be careful of misquoting one source and then that lie becoming fact.
Absolutely, and I think that's a danger that people generally face when they copy other people's works. Just as an aside, it's a bit of an anecdote, but it's a tip we often give clients to prevent copying of their documents. We tell them to purposefully make a little mistake. So then if somebody does copy their work, word for word, it's perfectly obvious because that mistake is there.
That was an old school trick when you had your mate next to you cribbing, and you'd so the teachers would bust them. Janine, when you look at the MoneyWeb court case, what are some of the interesting judgments that come out of the court case for you? Let's talk about the issue of originality first.
Yes, so there were a number of articles that were referred to. I think there was about 11, and the court found that there wasn't originality in relation to, I think, 4 or 5 of them. And that what happened, what I thought was a very well reasoned judgment, because it went through the steps when you're going to determine copyright and say, well, is the work original or not? And when the judge looked at that, he said, well, those works weren't original, so that he didn't have to go through the next steps, which with the other works he then had to go through the next steps. So if you don't pass originality, then you don't get through the gate. Now in South Africa, originality, there's a very low threshold. It doesn't have to be original thought. It's a total original thought. All that our courts require is that it has to be that you've spent some time, effort, and skill in drafting an article. So in some of those, they said, well, it was really a copy of what was said, or a copy of the press release, for example, so that there wasn't any originality in creating that supposed new document.
Journalists busted for just republishing and rehashing press releases. I think, there's a bit of red face there as well. Hugh?
Yeah, the originality aspect was really interesting. What Judge Berger found was that, to a large degree, that MoneyWeb didn't lead sufficient evidence to show that the work was original. And what he found was that if you interview an individual, the mere repetition of that interview doesn't constitute an original work. There has to be something more, and that's quite an interesting step in copyright, because the original approach that was taken was that sweat of the brow, and that idea is slowly changing. It was it's referred to in the case. There's a Waylight Diaries decision where Judge Hurrams was the first judge to move away from sweat of the brow and say there has to be something more than mere effort.
Well, it's intellectual property at
exactly.
the end of the day. It's not effort property. So you've got to show that you've applied your mind, you've looked at it with a rational perspective and applied your own analysis.
Exactly, and that's what Judge Berger found with the three articles where there was originality. That there were interviews, but the interviews weren't obviously repeated verbatim. They'd been analysed. There was a bit of thought given to the interview. There was an analysis of the interview, and the interview was clearly not reported verbatim.
The Defence X articles, which showed a clear investigative journalism at its best, I suppose.
Exactly.
And, I think once again this boils down to what sort of journalism we're talking about here, whether or not it's covering what the Cabinet said at a post-Cabinet briefing, where everyone has access to the same recordings and then repeats those, or whether or not someone goes and op-eds and analyzes that, or whether or not it's a full-on investigative process. And it's almost a difference here between investigative reporting and hard news reporting. Vicky?
Yes, I agree with you. I think, the Copyright Act itself specifically states that copyright won't subsist in news of the day that are mere items of press information. So, for example, as you've said, a statement or an interview that gets released, copyright will not subsist in that, and the mere sort of transcription or reproduction of a document or an interview of that nature would not qualify for protection as a work of copyright. But as you say, it gets slightly different when someone is actually analysing and making their own comments in relation to press releases, etc.
And there's also an idea here about the amount of work that we're allowed to filch. What did the judgment reveal about that, Vicky?
It's not really something that the judge pronounced specifically on, but reference was made to Fin24's aggregation guidelines. And MoneyWeb tried to use this as an example of the fact that they have a policy of plagiarizing other people's articles. And one of the guidelines, I'm not 100% sure what aggregation guidelines are, but it seems to be some sort of internal guideline that's applicable to the journalists and when they're writing articles. The first guideline that they laid down is that never use more than 30% of the original source. And it's a common misconception that if you use less than a certain percentage of another work, that's sufficient to avoid copyright infringement. But what the court confirmed, once again, is that this assessment is a qualitative assessment rather than a quantitative one.
Because you can take 28% of the real heart of someone's original work and pass it off as your own. So, it makes absolute sense that. Janine?
Yes, of course. I totally agree with that. It always goes about, it doesn't go about how much you take, it goes about what you take. And that is an assessment that the court has to take.
And now, I think an important development in the case was that the court laid down a few factors that should be taken into account when you determine fairness. And I think this is also quite interesting as well, Janine. What did the judge rule in terms of what we need to take into account when we're looking at the fairness of an issue when it comes to copyright?
Well, also what he did say was that each matter will have to be dealt with on the set of the own circumstances, and I think that's really important, particularly with copyright and also with such a term as fair use. But the court did say that it concerns the nature of the medium in which the works have been published, whether the original work has already been published, the time lapse between the two publications, and the amount, quality, and quantity of the original work, and the extent of the acknowledgement given to the original work. Now, with the Copyright Act, if copyright infringement has been established, then there's a numerous amount of exemptions, and they apply very specifically. Say, for example, the exemption that was applied in this case goes about news of the day. And what makes copyright quite tricky sometimes is that the exemptions don't apply for all types of works. So also here again, the fair use criteria will have to be looked at, I think, differently if you're looking at different types of works. I'm not sure what the rest of the panel say about that.
Hugh, what do you say about that?
Yeah, that's absolutely correct. Just as an aside, and for me, one of the interesting things in the judgment was around the extent of the acknowledgement, because in this exemption, one has to acknowledge the author of the work. And,
I was going to ask.
Yeah, what Media24 did, what Fin24 did, was they had a hyperlink to the article, and Judge Berger found that was sufficient for acknowledgement of the author. And I thought that was a great judgment, because what it's doing is it's recognizing the modern technology, the medium, yeah, correct, and that there are ways of of working other than the traditional ways, and I just think it's a great move. It will move in the right direction. It's recognizing that the new platforms are workable, and that the Copyright Act can work within the new media.
It's digitally progressive, I think,
exactly.
when you look at it. And it's very important here because we're moving into an era where, especially on the media side, the presses will be burned one day. It will happen. We're moving into a digital world. I mean, the advertising revenue is drying up. You see the ABC circulation numbers that were just released the other day. Circulation is plummeting again. And so we need to have a framework of how we operate in a world where aggregation is the key. You have sites that just are sole aggregators, really. They don't really produce any original content in essence. They don't have journalists going out to press conference. And so it's important to understand all of this, Vicky, to be able to operate in the new media.
Absolutely. I think the difficulty is that it's, and as Janine mentioned earlier, it's so easy in the age of the internet and digital media to copy someone else's work. And many people, like you say, believe that if it's on the internet, it's free to be used. And that's just not the case. So I think it's very important to educate people that although these principles of copyright law are quite old, they are equally applicable in the digital age as they were before.
Janine, as we get to the end of the panel, and if you were to dispense some advice for free, I'm hoping you're not charging me by the billable hour for this and doing some pro bono work again, but what would you advise content creators, be they individuals or companies, before they post something online? I suppose is always to think about what you post online, High Court judge or not, depending on what you're posting, but what else could you advise us when it comes to IP online?
If it goes about posting or using content of somebody else, what you can also do is there's something called Creative Commons, which has been established for quite some time. And what it does allow is for consumers or third parties to use works under certain terms. So, for example, you can use it only for non-commercial purposes, or you can use it for commercial purposes. Interestingly enough, on Google, if you go to Google Images and you go to Search Tools, there is a Usage Rights tab. And if you click on that, it's got certain further categories under that. For example, labeled for reuse with modification, labeled for reuse, for example. So what I would suggest is try and look a bit more, because there's so much information on the internet to say, can I use this image? And in some instances you can. And also, for example, if you're going to start a business, try and look at the images on the stock libraries, because there's so many stock libraries out there, and it's actually not that expensive to use that. But also, if, for example, you're creating your own material, your own images, and you want to check if somebody else is using it, there's two very useful tools called TinEye and Google Reverse Images. And what you do on those, I've tried Google Reverse Images, is to upload your image. And what Google does then is to show you where those images are used, which is very, very useful for a creator to try and locate or identify where their works have been used.
Oh, that's very interesting, because it also it then closes that space where you feel you're not going to get caught, so I'm just going to quickly nick an image. Hugh, what steps can I take if I've discovered that my work has been used illegally? I feel my work has been used illegally. What should I do?
Well, the first step would be obviously to talk to an attorney who is familiar with this kind of work, and then one would address a letter of demand to the infringer. Hopefully the letter of demand is received favorably, and my experience is that normally they are. If they're not, well, then you're left with very little alternative but to go the nasty legal route, which is something that mustn't be taken lightly. It's a very nasty route to go, and the advice I give to the clients is, they really need to think about it. It's the last thing you think of when you go to bed at night, and the first thing you think of when you wake up in the morning. And the decision to go the litigation route is not an easy one. Theoretically, one can lay a criminal charge, because it is a criminal offence as well. Copyright infringement is a criminal offence as long as there is knowledge. But my experience has been that there's very little enthusiasm on the part of the South African police services to follow that through. They've got other issues to worry about, and I think they regard it as pretty much a trivial crime. So the options ready to go the civil route, but it's not a decision to take lightly.
Yeah, one has to look at the cost benefit analysis quite closely there. Vicky?
Agreed. It's a pretty basic principle, but something that hasn't been mentioned yet, and that is if you are publishing works on the internet or in hard copy, it's to protect yourself. It's very important to put a copyright notice on the work, just to give notice to the public that copyright subsists and that you're the owner of it. It also assists you in proving there was copying.
And enforcing your rights when it comes to that stage. Well, we've reached the end of our time. I've certainly found that very interesting, very informative, and I hope the listeners did too. Tin Eye and Google Reverse. Look those up, and I'm going to now to see if anyone's been nicking my images and passing them off as their own. Thanks to all my guests tonight: Hugh Melamdowitz, partner at Spur & Fisher; Vicky Stillwell, trademark attorney and consultant at Quiche IP; and Janine Hollison, director at Worksman's Attorneys. Join me tomorrow night for quite an interesting interview that I conducted with one of the top women in tech earlier on this week. From me, Michael, producer Amo Khlakla, and sound engineer Mdu Tele. Thanks so much for listening, and have a good copyrighted evening.